If you're experiencing discrimination at work, you're going to want to watch this video. This is Christian attorney R.L. Johnson, lawforlife.us. If you're new to this channel, I explore legal issues from a Christian perspective. So if this perspective interests you, please be sure to subscribe to my channel. In this video, I will tell you how to fight employment discrimination based on race, color, religion, sex, or national origin. Now, job discrimination is prohibited by law. Specifically, it's prohibited by Title VII of the Civil Rights Act of 1964, which prohibits employment discrimination based on race, color, religion, sex, which includes on the basis of pregnancy, childbirth, or a pregnancy-related medical condition. Title VII also prohibits discrimination based on national origin. Now, there are other laws that protect workers from discrimination by reason of, say, disability. For example, the Americans with Disabilities Act of 1990, or on the basis of a person's genetic information, which is prohibited by the Genetic Information Non-Discrimination Act of 2008. And there are also laws that protect workers from discrimination based on their age. For example, the Age Discrimination and Employment Act of 1967. However, because the scope of these laws is fairly narrow, in this video I will only discuss Title VII of the Civil Rights Act, or hereafter referred to as simply Title VII. In a typical situation, employment discrimination arises after an employee or a prospective employee is made aware of a job requirement or excluded from a job opportunity by reason of the person's race, color, religion, sex, or national origin. The other class of cases involve an employee who encounters hostility or an adverse reaction from the employer when he or she objects to a condition of employment on the ground that it conflicts with a religious belief. In these instances, Title VII imposes upon covered employees, which is to say not all employers are covered by the Act, but it imposes upon covered employees a duty to accommodate the employee's religious observance or practice, provided that is, the accommodation does not impose an undue hardship on the conduct of the employer's business. Now, note well, an employer's duty to accommodate applies both to current employees as well as job applicants or prospective employees. It also applies to the federal government, employment agencies, and labor organizations. Keep in mind, however, that Title VII does not apply to all employers or all employees. For instance, Title VII doesn't apply to employers in both the private and public sectors with fewer than 15 employees. So there has to be at least 15 employees or more before Title VII would apply at all. Title VII does not apply to a bona fide private membership club that happens to be exempt from taxation. That is to say, the IRS does not require such a bona fide private membership club to pay federal income taxes by virtue of its charitable status. Title VII also doesn't apply to an employer incorporated in a foreign country where that employer is not controlled by an American employer. Title VII doesn't apply to aliens working outside of any state. Incidentally, the term alien is defined elsewhere in federal law as any person not a citizen or national of the United States. Title VII also doesn't apply to a religious corporation, a religious association, or a religious educational institution where the work to be performed is connected with that entity's mission. Now, Title VII is enforced by the Equal Employment Opportunity Commission, or EEOC. So if you're experiencing adverse employment action by reason of your race, color, religion, sex, or national origin, you've got 300 days from the date of the adverse employment action to file your claim with the EEOC. The EEOC has authority to investigate whether there's a reasonable cause to believe discrimination actually occurred. Within 10 days of receiving your charge or complaint, the EEOC will notify your employer that you've made the complaint. At this stage in the process, you have to remember that your charges are just that, allegations, as nothing has yet been proven. Also, having received your notice of charges from the EEOC, your employer may elect to resolve your concerns through mediation or settlement. Now, mediation is an informal process usually, or it can be a formal process, wherein a neutral third party works to find a point of agreement between you and the employer and bring the conflict to a fair resolution. Consequently, at the onset of the investigation, the EEOC will let both you and the employer know if it thinks your complaint is eligible for voluntary mediation. That said, you may nonetheless ask the investigator about voluntary mediation or settlement options on your own without being prompted. The EEOC may also investigate your charges. During the investigation, both you and your employer will be asked to provide information. The EEOC investigator will evaluate the information submitted and make a recommendation as to whether there is a reasonable cause to believe that unlawful discrimination has taken place. If the EEOC decides to investigate your charges of adverse employment action, but is unable to conclude that there was a reasonable cause to believe that discrimination occurred, you and your employer will be issued a notice called a dismissal and notice of rights. This notice informs you and the employer that you have a right to file a lawsuit in federal court within 90 days from the date of its receipt. That is, the receipt of the dismissal and notice of rights. Your employer will also receive a copy of this notice. On the other hand, if the EEOC determines that there is reasonable cause to believe discrimination has occurred, you and your employer will be issued a letter of determination. This letter will state that there is a reason to believe that discrimination has occurred and will invite the parties to join the agency in seeking to resolve the charge through an informal process known as conciliation. Now, if conciliation does not succeed in resolving the charge, the EEOC has the authority to enforce violations of its statutes by filing a lawsuit in federal court. If the EEOC decides not to litigate, you, the charging party, will receive a notice of right to sue, sometimes known as a right to sue letter. With this letter, you may file a lawsuit in federal court within 90 days of your receipt of the right to sue letter. Now, that said, there are also circumstances in which the EEOC is not able to complete its investigation in the 180 days that it gives itself to get the investigation done. Now, if it's not able to get it done within that 180 days that it sets for itself per its own policy, you will receive a notice of incomplete investigation. Now, in this letter, you'll be provided with notice of your right to request a hearing before a commission, that is, an EEOC administrative judge. Alternatively, with that letter in hand, you can file a civil action in the appropriate U.S. District Court. One thing people have to keep in mind before running to the court when you have a claim alleging discrimination based on race, sex, national origin, or religion, and that is a doctrine called the Exhaustion of administrative remedies. In short, what this means is that before you run to the federal court with a lawsuit, or even a state court with a lawsuit, you had better have given the EEOC an opportunity to either investigate and find there's a basis for believing discrimination occurred, or to fail to complete the investigation within the prescribed 180 days and issue you a notice of incomplete investigation. If you fail to do that, you're going to file a lawsuit and you're going to find your lawsuit dismissed because you failed to exhaust the administrative remedies. This is a doctrine that has stopped and derailed many lawsuits. So you really do need to let the process play itself out as I've outlined above. So again, within 300 days of the adverse employment action, that is to say when you knew or should have known that adverse employment action was taken against you by reason of your race, your color, your religion, or your sex, or your national origin, you must file a complaint with the EEOC. Now, this remains the case even if you have, under some state statutes, a cause of action under state law for discrimination based on race, sex, national origin, or religion. And that is to say, there's something called the preemption doctrine, which is to say that the federal government, through Title VII and other similar legislation, has essentially dominated the field. So your state court case could be removed to the federal court, where you could be accused of not having exhausted administrative remedies. So there's nothing to be lost by having the EEOC investigate your complaint first. In fact, it's required. Now, once you receive your notice of right to sue, which can come either through a failure of the conciliation process, or it can be issued on request if, for example, the EEOC does not complete the investigation in the prescribed 180 days, then must file your lawsuit in a federal court within 90 days of receiving the notice of right to sue. And one final word about exhaustion and state law. Now, there are state statutes that prohibit discrimination in the workplace. Where these state statutes apply to the facts of your case, which is to say where you're able to use a state statute in order to protect your rights as an employee, the doctrine of exhaustion generally will not apply. And this is handy sometimes where you missed the 300-day deadline for the federal act under Title VII or federal action under Title VII, because many state statutes will allow you to file the claim sometimes up to 3 years after you knew or should have known about the adverse employment action. So I don't want to give the impression that a state action may not be warranted, because in some cases it may be your only recourse. Also, the definitions of discrimination may differ, which is to say they might be more stringent under the state law than they are under the federal law, which might make it easier to proceed at the state level. But again, I would strongly recommend that you allow the EEOC to investigate your complaint first before you explore other remedies. And the final thing to take away from Title VII is that you are generally entitled to reasonable attorney fees under Title VII if you're successful. This is a big deal when you're looking for an attorney to represent you in a case where you don't have $15,000 to $20,000 to put down as a retainer. Now, with that overview, hopefully you and your employer can resolve the dispute either through formal or informal mediation. Failing that, however, I placed a link to the EEOC's website in the description box. If you find this content useful, please be sure to like this video and to subscribe and share this channel. Also, if you're looking for more information or resources on this subject, I posted an article on my blog, lawforlife.us, where you'll also find other helpful information, content, and resources. Thank you for watching. God bless.